Welcome, everyone, to another edition of our employment rights question and answer sessions. My name is Samara Belitzky. I'm an employment lawyer with Samfiru, Tumarkin, and I work out of our Ottawa office. I'm here for the next half an hour or so to answer all of your questions related to employment law. So workplace issues, terminations, severance, safety and health and safety issues in the workplace, you name it, whatever it is that you have on your mind, something that you've been thinking about with respect to your employment. Now is the time to send in your question, and I will be more than happy to answer it. So send in all the questions that you have, and we will get to as many as we possibly can. In the interim, while we're waiting for some questions to come in, as always, I have a few things that I have planned to talk about, things that have either been in the news this week or last week, things that are really, we're seeing kind of trend in terms of news topics, and things are also we're getting lots of questions about. So things that people have been asking me about over the last couple of weeks that many of you may be wondering about as well. So we'll get to as many questions as we can, so send them in. And for now, the first thing that I wanted to talk about was mass layoffs. So we've seen it in the news week after week now. It seems like every week there's another company or two or three that are going through a mass layoff. And so what's important to know is that when you're dealing with a mass layoff, if you are unfortunately somebody that has been impacted, you've been let go as part of a mass layoff, whether it's an individual termination, and you're the only one let go, or maybe you're one of two or three or four, or maybe you're one of 200. Either way, the first thing to know is that you are owed severance. The second thing is you should be making sure that you're getting what you're owed. Oftentimes when we're dealing with mass layoffs, especially, employers will provide just the bare minimum that's owed under the law, the minimum standards at law. They won't likely offer you your full severance right off the bat. Maybe they will, but in most cases, they won't. Either way, no matter what it is that you're being offered as an employee, if you are affected by a layoff, it's really important to get legal advice from an employment lawyer on what your rights are. How much severance could you be owed? How does that compare to what it is that you've been offered? And of course, if there's a discrepancy there and you're owed more than what you've been offered, we're more than happy to help you pursue that and to secure exactly what you're owed. So never sign without speaking with an employment lawyer first. You may be in a situation where you're being let go. And again, this applies to any sort of termination, whether it's a mass layoff or an individual termination, any termination. The employer may pressure you and say that you have to sign right away, otherwise you're not going to get severance, or simply just try to get you to sign right away without speaking to a lawyer. Don't succumb to any pressure that may be imposed on you. It's really important to get legal advice and make sure you know exactly where you stand before you sign anything. Because once you do sign something, you will be stuck with it. And it's possible that you might sign something and be owed a ton more of severance, and then you won't be able to pursue that because you've signed the documentation. So it's really, really important not to sign. You always have the right to take your time, think about what's being offered to you, and seek proper legal advice. So when we're dealing with mass layoffs, again, the termination of your employment, whether it's in a big group or just on your own, means that you will be owed termination entitlements. So it's not going to change necessarily just because it's a mass layoff. And so you really need to make sure that you're looking after yourself and making sure that you're getting what you're owed, especially in a case where you might be seeing, if it's a mass layoff, you might be hearing from other people what they were offered, what they're doing. Focus on yourself. No two cases are alike. So you need to make sure that you're getting the proper advice and moving forward based on what exactly your severance entitlements or termination entitlements might be. Okay. In terms of mass layoffs specifically, there are provisions in the Employment Standards Act. For example, in Ontario, there are provisions with respect to mass layoffs. And so in the Employment Standards Act, which does contain the bare minimum severance or notice that somebody would have to receive when they're let go, there are heightened and increased obligations for employers when we're dealing with a mass layoff or a mass termination. And under the Ontario Employment Standards Act, for example, that would be anywhere when an employer, for example, is letting go of 50 people or more. So if the employer is letting go of at least 50 people or more, that's when those heightened obligations and those increased obligations will kick in and they'll be triggered. And so if you're dealing with a situation where you have, let's say, 4 years of service with the company, maybe your regular termination entitlements under the Employment Standards Act, again, just your bare minimum might be 4 weeks. That's your starting off point. But when you're in a situation of a mass layoff, it will actually be more than that. Now, again, I'm only talking about bare minimums. Most people are owed more than their bare minimums when they're let go. Usually people will be owed their full severance. So we're just talking about bare minimums here, and there will be a difference in the bare minimum when there's a mass layoff, and the employees will be owed more when you're part of a mass layoff, again, under the Employment Standards Act. When it comes to your full severance, there's no difference. Whether it's an individual layoff, a mass termination, it doesn't matter. What's owed is what's owed. It doesn't change. It doesn't go higher or lower, depending on whether it's a mass layoff or not, when we're dealing with your full severance, your full termination entitlements, which is what by default people are entitled to receive. So I have a few questions coming in. I had a few other things I wanted to discuss, the kind of hot topics that we're seeing over and over again. If you do have any questions about mass terminations or mass layoffs, please send them in. We've been getting so many people contacting us about this. Unfortunately, so many people have been impacted by these huge layoffs and mass terminations over the last little while, including even as of today. We just got word that there are other mass layoffs that are taking place. For example, Best Buy seems to be undergoing a mass layoff as well. So if you are impacted by this or you know somebody who is, please send in your questions. Happy to answer your questions and help however I can. I'm just going to get to some of the questions I'm getting in here. Teresa on YouTube asks if we're answering questions regarding dismissal due to not taking the COVID-19 vaccine. Sure. Teresa, send in your questions. Let me know what's going on. Happy to answer any questions you have about that. If you or someone you know has been let go because you didn't receive the COVID-19 vaccine, it's definitely an interesting and complex legal issue that we've all been dealing with for quite some time now. And we've had lots of cases related to this issue. So please do send in your questions. Happy to answer them. So I have a question here from Philip on YouTube, who says, BC new sick days are now 10 days. Can an employer make up how employees can use the new extra 3 days? For example, calling them personal days, and it is 24 hours to be used by the hour. Also, the usual 7 sick days being called rolling 12 months, not going by the calendar year. So in terms of what you're asking, Philip, it's with respect to, in BC, there are statutory obligations. So there's the Employment Standards Act, which is a law that exists in every single province. It does differ from province to province. So I'm going to answer and address Philip's question, but it is with respect to BC only. So if, let's say, you're in Ontario, this is different. In Ontario, for example, there are no paid sick days that are outlined in the Employment Standards Act of Ontario, except for right now, there is one exception, which is if there are sick days that need to be taken related to COVID-19, an employee can take up to 3 days of sick days if it is related to COVID-19, and those would be paid. And then the employer would actually have to pay those days and then can go make a claim to the Workplace Safety and Insurance Board, the WSIB, to get reimbursed for the pay. So that's how it currently works in Ontario. In BC, with respect to their Employment Standards Act, there would have been a change in the law with respect to how many days are allotted at law. Once again, these are minimum entitlements. So just because the Employment Standards Act either doesn't have sick days or maybe does have sick days, that doesn't stop an employer from providing more than the bare minimum to their employees. So I deal with lots of employees who have an entitlement to a certain amount of sick days in a calendar year. Just because the provincial law doesn't outline that there are paid sick days owed as a bare minimum, or just because it only outlines 7 or 10, whatever the case may be, the employer can always provide more than that. And if, let's say, as an employee, you sign a contract that says you're owed 14 sick days a year, then that's what you're owed. It's not the Employment Standards Act, excuse me, it's what's in your contract, okay? So with respect to the Employment Standards Act in BC, Philip, with respect to your question, the employer cannot contract out of the Employment Standards Act. The employer has to follow it to a T. So it cannot change the way in which these days are being allotted. It can't tell you how you have to use those days. If they are provided by law as a minimum by the BC Employment Standards Act, then that's where the qualification stops. The employer doesn't get to decide how those days get used. If they're sick days, they're sick days. So you'd have to refer to the Employment Standards Act in terms of what they could be used for, which of course is a very broad heading. If, let's say, you're having an issue where your employer won't let you use sick days that you have a right to by law, then you're going to want to get in touch with us so that we can assist you further, because then the employer would be in a situation where they're not complying with the law. Okay, so you certainly can call us, you can email us at help@employmentlawyer.ca, and somebody will get back to you. If you're in a specific situation where you're trying to take your sick days, they're owed to you at law, your employer is not letting you, you certainly should be getting in touch with us. I have a question from Helen on YouTube. How long does it take for wrongful dismissal after filing a lawsuit in a Supreme Court now? If the evidence is evident to justify, could you please talk about if it is suited for summary judgment? Okay, Helen, I'm not sure which province you're in. Depending on which province you're in, the answer will vary slightly. So I can tell you, if you're talking about Supreme Court, you may be out west, but in Ontario, for example, the court where you would be filing a wrongful dismissal claim is called Superior Court. That's the first level of court for any claim over $35,000. Anything under $35,000 would be in small claims court in Ontario. Okay, you're in BC. All right. So then in BC, as I suspected, you're out west. So when you are filing for wrongful dismissal in BC, I'll just give a couple examples. So just to finish what I was saying, in Ontario, it's called the Superior Court. And of course, the Supreme Court is the Supreme Court of Canada, which you would only get to if you have several appeals of a case. In BC, if you're filing a wrongful dismissal case in Superior Court, or I should say the Supreme Court in BC, that's your first instance court. That's where you would be filing your claim in order to pursue additional severance, because that's what a wrongful dismissal claim is. Wrongful dismissal claim is specifically to pursue severance. So oftentimes when we're talking about a wrongful dismissal claim, because of the way it's worded, people say, they were wrong to let me go, because it's right in the name, wrongful dismissal. But actually what a wrongful dismissal is it's not that they were necessarily wrong to let somebody go, because an employer can actually let an employee go at almost any time for almost any reason, as long as they provide them with their termination entitlements that are owed. And so with respect to a wrongful dismissal, what that means is you either haven't received any severance pay or any notice, or you've received some, but you haven't received enough. And so when you're filing a claim for wrongful dismissal, it means you're going after additional severance pay that would be owed. In terms of how long it takes, it will vary depending on the case. It really will be different depending on what the facts of the case are. If there are many facts in dispute, for example, if you've been terminated allegedly for cause meaning your employer has said you engaged in misconduct, that means that a lot of the facts will be in dispute. And if that's the case, that means that your case will have to go through the full court process. Certainly it can settle at any time, and many cases do, but there's no shortcuts in terms of getting to a trial. You'd have to go through all the different steps because of the fact that there are facts in dispute. And it's the same thing in any other province. In terms of a case where it's maybe a without cause termination, which is just a regular termination, and the only issue at play is how much severance is somebody owed, and the employer says one amount and the employee says a different amount, but all the other facts are agreed upon between the parties. Everyone agrees that the employee was a certain age, they worked there for a certain period, this was their position, this was their pay. It's really just about how much severance is somebody owed. That's where it could be suitable for a summary judgment motion. And that's that kind of shortcut I was talking about before, where you can get to a resolution or you can get to a hearing much faster than when you're in a complex situation where maybe it's a cause termination, maybe it's a constructive dismissal situation. But whenever it's more complex and there are facts in dispute, that's where it will be hard to proceed by way of summary judgment. But certainly if everything is, in agreement, the facts are not in dispute, it's really just about severance. It's just a legal question that you're asking to the court. That's where you could proceed in theory by summary judgment. And you could have a quicker turnaround there. Maybe it's within a year or so. It really depends. The courts, unfortunately, are quite backlogged right now. So, you would be looking at likely in the range of at least a year for a summary judgment hearing, if not longer. I hope that answers your question, Helen. A couple more questions here. I have a question from Lori on Facebook who asks, can you be forced to take on another role within your department? My boss says I signed a contract that says I can be asked to take on other duties, but nothing was specified. Very good question, Lori. This is something we deal with, unfortunately, pretty often. So the answer is it depends. Generally speaking, you can't be forced to take on a whole other role. If you were hired for one role with a certain set of duties, being paid for that role, your employer cannot insist that you take on a whole other job with the same pay. Okay, so they can't do that. If they were to do that and say, unless you agree to taking on another job and doing two jobs, and we're only going to pay you for the one job, you certainly would have legal recourse there, and we could assist you with that. You would be able to assert a claim for constructive dismissal and go after your severance. However, employers are able to make some changes to your duties without there necessarily being legal recourse. And so when we're talking about whether you have legal recourse, whether you can claim constructive dismissal or not, potentially, we really have to be looking at the context and all of the circumstances and assessing whether the changes that are being made are being forced upon you. That's number one. They have to be unilaterally being forced upon you by the employer. They have to be permanent. So it's not something that's just temporary. Maybe it's for a couple of months. That's different. This would have to be permanent. And it would have to be a significant change to the fundamental terms of your employment. So if, for example, the employer is making very small changes to the duties and maybe assigning you an extra duty or two that is in line with what you're already doing, and it's something that's, basically goes along with what you're already doing, that may not be something that you would have legal recourse for. But again, if it's a significant change where your employer is either removing a lot of duties or adding a lot of additional duties that are not related to your job, that are not things you've done before, that are very significant changes, that's where you would have legal recourse. Keep in mind, Lori and anyone else who's in this situation, it's really important to get legal advice from an employment lawyer before you do anything. These situations can become complex. They're situations that we deal with all the time, and we can assist you and guide you through the steps to make sure that you're taking the steps you need to protect yourself. And so it would be very important to consult with a lawyer to see, number one, is this something you'd have legal recourse for? What can or can't your employer do? And I did give you, some of the factors that we look at, but again, it has to be a very significant change with respect to your duties. And then we would look at your options and how best to go about pursuing any legal recourse. So certainly be sure to get legal advice. You don't want to put yourself in a situation where you quit on the spot because you don't like the change and you don't think they can do it. You quit on the spot and then you contact the lawyer 2 weeks later, 2 months later. You're not going to be in a situation where you'll have the strongest case possible. So you really want to make sure before you do anything, you speak with a lawyer. You can contact us. We can guide you through it, let you know what your options are, and then you can go from there. So Teresa on YouTube, I'm just reading through your different submissions here. So Teresa has said that she was let go on October 15th, 2021. It's unclear whether that was an unpaid leave because this is related to not being vaccinated. So it looks like you may have been placed on an unpaid leave October 15th, 2021, and then you were subsequently let go and terminated, seemingly for cause without being offered any severance. If that's the case, then it will depend on the circumstances of when you are let go, who you worked for, because there were certain mandates in place in 2021. So I would just need to be sure of exactly when you were let go and whether your workplace was impacted by any government laws or mandates. If they weren't, there was no law in place at the time of your termination and you were terminated for cause, you will very, very likely be owed severance pay. I would have to examine all of the circumstances of your situation. So Teresa, get in touch with us. As I mentioned before, you can always email us at help@employmentlawyer.ca. You can also email me directly. You can go to our website, employmentlawyer.ca, go to my profile. My email address is there. You can contact me directly. So you have options, but definitely get in touch with us so that we can assess your situation, because based on the information you've provided, it does sound like you would be owed severance. I can't tell you how much you would be owed without any of the information that I would need, like your age, your length of service, your position. But once we get all that information and we can assess your case more accurately, certainly would be happy to assist you. And for anybody who's in this situation, we don't have as many of these cases coming up as we did over the last year or so, but it's important to know that the employer does not have an automatic right to place an employee on an unpaid leave of absence. And if you have been terminated for cause, or you are terminated for cause because you're not vaccinated, that is something that you can push back on, and you certainly would have legal recourse to pursue severance. So certainly get in touch with us. Happy to assess your case, let you know where you stand, and then assist you in terms of pursuing your severance. I have another question from Helen on YouTube. Can I apply for EI sickness benefits when reaching the end of the EI benefit? I have a doctor's note. So in terms of the difference, just for everybody who's tuning in today, EI sickness benefit is a specific type of benefit that is available to people who go on medical leave from their jobs. So that would be if, let's say, you have to go on a medical leave and you don't have short-term disability benefits either through your work or your own personal insurance policy, then you would go on EI sickness benefits. You can apply with your doctor filling out a form. And your employer would provide a record of employment outlining the fact that you're on medical leave, and then you'd be able to apply to Service Canada for EI sickness benefits, which lasts for up to 15 weeks. And that is different from regular EI benefits, which are the benefits that are available if you are let go from your job. So if you're put on a layoff or you're let go from your job, permanently, that's where you would be applying for EI benefits. So in terms of the way that Service Canada processes these claims and deals with them, you wouldn't necessarily be able to have both. So I would speak with Service Canada because Unfortunately, depending on who you speak to, sometimes you may get a different answer. But generally speaking, you wouldn't be able to have both. It would be the one that applies to your particular situation. And if you've maxed out EI benefits, there likely wouldn't be approval for EI sickness benefits. But again, speak to Service Canada directly because you may be able to make some progress there. So I would recommend that you call them, you outline your situation, tell them what's going on, and see what they recommend. I have another question from Philip on YouTube who asks, if an employer is bought out by another company, but the roles have not changed, would they have to have an employee sign a new contract? The short answer is no. What you're talking about is when there's a sale of the business and a new company comes in and takes over ownership of the company. So essentially, everything stays the same. Your job is the same, your pay is the same, your hours are the same. There's no break in service, but the name of the employer, the owner of the company, has changed. That's the only difference. When that happens, oftentimes the new company that has taken over will have or ask their employees to sign new employment contracts. From an employer perspective, that's not something that you'd have to do, but it is something that most employers do. And from an employee perspective, it's not by law that the employer would have to do that. So if you're in a situation and the employer is saying they have to present you with a new contract, that's not true. But they can, and they have the right to present a new contract if they want to. As an employee, you have the right to choose whether you sign that or not. You don't have to sign a new contract. Most of the time when I have consultations with people who have been presented with new contracts while their employment is ongoing, we'll go through the contract and see if there are any red flags. But oftentimes, if you're an employee, what you need to be looking out for is that they likely are trying to limit your termination or your severance entitlements. So oftentimes, we will advise people not to sign the new contract if it does contain language that will limit their severance. So it's really important that anytime you're presented with a new contract of employment, even if you're starting a new job and you've been given a new offer of employment or a contract, or you're an employee continuing on, maybe there's been a sale of the business, maybe the employer is just deciding to introduce contracts, whatever the case may be, it's really important to get it reviewed by an employment lawyer to make sure that you know exactly what it is you're being asked to sign and that you understand what it is you're signing before you sign it. You may end up still signing it, but at least you're making an informed decision. 9 times out of 10, the contract will have clauses or provisions in there that are really not beneficial to you as an employee, but they are beneficial to the employer. So you really just want to be careful that you don't sign something that you don't understand, because again, then you'll be stuck with it. So that's something that does happen often enough, and it's really important to make sure you're getting proper legal advice before you sign. We're just getting to the end of our time here. I'm going to answer one more question, and then anything else that hasn't been answered, we do have another question and answer session next week. So just keep an eye on our pages, and you'll be able to tune in for that. Or you can always email us at help@employmentlawyer.ca. So the last question is from M. Ellie on YouTube, who says, I'm on unpaid leave for refusing vaccination, but was told last year I can't get severance because I'm an LTC employee, long-term care employee. Has this changed now? And you're mentioning that you were given a legal opinion by our firm. I cannot tell you, what has changed or not changed about your situation because I don't have all of the information. Whatever it is that you would have been told by our firm would have been accurate, especially would have been accurate at the time. In terms of long-term care, the mandate that the government had in place in Ontario for long-term care homes has been lifted. So it's possible that at the time that you spoke with our firm, if you did, or whoever you spoke with, that the mandate would have been in place. So when the government changed the law to say by law you have to be vaccinated in order to keep working in a long-term care home, there would have been no legal recourse available. At this stage, because the mandate has been lifted, and since the mandate has been lifted, there would be legal recourse available. Okay, so certainly if that's your situation, you should get back in touch with us, and we can look at your case and let you know if you do now have legal recourse, given that the mandate has been lifted. Okay, so definitely get back in touch with us. Again, I see that we have more questions coming in, but unfortunately, we are at the end of our time here. So again, if your questions weren't answered, please feel free to send them in our next session next week. Otherwise, you can email me directly or email help@employmentlawyer.ca. Thank you very much, everybody, for tuning in today. Thank you for your questions, and I hope that everyone has a wonderful weekend.